Daf Kuf Yud Beis, sponsored the Refuah Shalema for Ilan Ben Mashachana. The first thing that the Gemara discusses is the status of an heir returning interest the father collected during his lifetime. On the previous daf, the Gemara brought a machlokas between Bava Kama and Rava as to the status of an heir regarding stolen property. There's another version of the machlokas. They argued about repaying interest that their father took from others. Bava Kama, he holds, in spite of the fact that the borrower paid the interest willingly, the lender is judged as a robber in some sense. Therefore, his children acquire by way of Yush and Shinu Rishus and do not have to return to the borrower. Rav, on the other hand, holds that interest is different than theft. Since the borrower paid it willingly, even without Yush, it belongs to the lender. The Torah commands us to return interest based on the pasuk, V'chai achicha imach, that your brother should live with you. He holds this command applies specifically to the lender, not to his children. The second thing the Gemara discusses is an application of the principle of Bari V'Shema, Bari Adif. There's an argument concerning this law. If the lender, for example, is certain that the borrower owes him money, the question is, in such a case, does such a claim suffice to extract money if the borrower is not sure whether he borrowed or not? However, if he did borrow and is uncertain whether he paid back, he is liable if the lender claims he is certain. So in other words, the machlokas is only in such a case where the borrower is uncertain of the loan. But if he's uncertain of paying back, then everybody agrees the one that has the tainus bari wins in court. Based on this, we conclude the brisa that elaborates on our Mishnah and claims the adult children have to pay the stolen property to the victim after their father's demise is because they admitted to the theft and yet were uncertain if the father paid the victim. The next inyan that the Gemara discusses is minor children, according to one brisa, are exempt from paying the victim. According to another, they are liable. Simply, Sumchus holds minors cannot be sued in court. The Chachamim who authored the second brisa, they hold that actually a minor can be sued in court. This will be elaborated upon in the Gemara upcoming. The law of heirs regarding borrowed property. Rava states that heirs can use an animal their father borrowed for the duration of the loan. They are not responsible for damage to the animal beyond their control, unlike a regular borrower, because they never accepted custodianship. If they slaughtered the animal thinking it was their father's, they must pay 2/3 of its value in the market. This is the value of their benefit. If the father left them real estate, then they must pay for the animal in full. The question is the last law of Rava, the father left them real estate, they have to pay the animal in full. Is that going back on both previous laws or only on the last? Meaning, the victim can claim payment even if no damage happened as a result of any action on their part, or just in the case where they slaughtered the animal. The Gemara answers, according to Rava, really there are two approaches to resolving this question. Rava holds that it refers to the first law as well, because the borrower's liability for onus begins as soon as he borrows the animal. If the father owned real estate, the lender has a lien on his property. It does not matter if he dies. the heirs have to pay their father's obligation. The second approach is they are liable to pay their father's obligation because by slaughtering the animal, in a certain sense, they stood in his place. Rav Papa, he disagrees with the first approach. He holds a borrower is different than a thief. He is liable when the item is damaged and not at the time of the loan. For example, one who borrowed an animal before Shabbos and slaughtered it on Shabbos is exempt. Why? Because of Kam Levi the Rabbineh. The liability for him as a borrower came at the time of the slaughter, which was on Shabbos. Since he was liable for a capital crime, he does not pay for the animal. Similarly, in our case, since the borrower was not liable in his lifetime, and his property is not lien to the loan, therefore the children, the heirs, do not have to pay. Expropriating property claimed by a minor. Although according to Sumchus there is no litigation against the minor, he agrees that if there is no basis for his claim, the court will evict the minor. But if there is a basis, such as his claiming property that belonged to his father, one cannot bring witnesses to prove otherwise until he becomes an adult. The next inyan the Gemara speaks about is the law concerning a court hearing testimony from witnesses not in the presence of the defendant. Number one, the defendant was summoned before the trial began because either the plaintiff or witnesses were ill or they planned to travel overseas. If he did not answer the summons, they hear testimony even not in his presence. The second circumstance would be, once the trial begins, they can hear testimony from the witnesses without extenuating circumstances, as long as they summon the defendant. The third situation is, if the trial did not begin, the defendant can request a change of venue. However, if the Beis Din Agadol in Eretz Yisrael provides the plaintiff with a letter that the local court is capable of judging the matter, he cannot request a change of venue. The next inyan in the Gemara is certifying a loan document not in the presence of the borrower. Rav and Rav Yochanan argue whether the court can certify the document where the witnesses intend on traveling overseas. Rava claims the halacha follows Rav, that it is permitted. However, if the borrower requests time to provide witnesses that the document is false, the court assesses how much time he needs and extends it to him. From the end of that period, he has 3 more court days to appear. If he does not appear, the court excommunicates him for 90 days. However, the court does not permit the lender to take his property during this time to allow the borrower, number one, to borrow money to pay his loan, or sell property and receive payment from the purchaser. At the end of these 90 days, the court writes a document permitting the lender to seize the borrower's property. In the case of a deposit, the court permits the lender to seize it immediately. The next thing the Gemara discusses is seizure rights that apply only to land but not to movable property. This is because the lender could consume his movable property that belongs to the borrower, and if the borrower proves the loan was forged, he has nothing to collect from. This is true even if the lender has property, because it may go down in value. Now, what about notifying the borrower of the lender's seizure rights? Normally, the court appoints an agent in court to notify the defendant on Tuesday, to send an answer on Wednesday, and appear in court on Thursday. However, if the plaintiff is a powerful man and the borrower will be unable to extract his land if he proves the loan document was forged, the court allows notification up to 12 months. The court's agent testifies the defendant refuses to appear in court. The court accepts his testimony even though he is one witness to excommunicate him, but not to write a document of excommunication because he cannot be released without paying. Since this involves a loss of money, 2 witnesses are required.